Today, we will be discussing time management and delays when it comes to workplace investigations and how to keep your workplace investigations on track. My name is Dorian Persaud. I am the senior lawyer at Persaud Employment Law. We are a team of lawyers that specialize in conducting workplace investigations and helping you to create healthy workplaces through investigations, training, and proactive advice. I want to welcome each of you, and especially those who may be joining us for the first time. This is a monthly event that we host and where we provide resources to those conducting workplace investigations. So we trust that you would enjoy today's session and that you'll join us for next month's session, at which time we'll be discussing how to assess the credibility of witnesses. So please look out for those communications that will be coming your way in the days ahead. With me is my assistant, Neha. She's going to be helping me with the questions and answers. As for those of you who've joined us before, you'll know that we leave a lot of time on the back end of these presentations to answer questions that you might have. So please do use the within the chat function, the Q&A link, and direct your questions to everyone. And Nehal will pick up those questions and feed them to me at the conclusion of today's presentation. So I am sure many, if not all of you, have had the experience of starting an investigation, or maybe you've brought in outside legal counsel to start an investigation and you thought the process would be wrapped up within a couple weeks, but after a few weeks you are looking at the situation and maybe it's and you're wondering, when is this thing going to conclude? You might be a couple months in and with still no end in sight. So at the conclusion of the investigation, you always want to look back and figure out what you could do differently, or how did these things arise that caused a delay. You hopefully with the information that we're presenting today, it gives you a chance to be proactive and to anticipate some of these events, because as we all know, investigations are dynamic. So what we want to do is try to make them as predictable as possible. So we'll go through some tips and some strategies that you can employ to help you keep the investigation on the timeline that you've laid out. The first strategy that we have is to create an investigation plan. And in response to that, you might be thinking, look, Dorian, I don't have time for any more work. I've got a lot of things on my plate. This investigation is already quite a bit of work, and I am hesitant to add any more to my plate. So all I can say to that is I hear you. I understand that, but a little bit of time that you spend on the front end really helps you in terms of managing delays during the process. So a little bit of time invested on the front end will save you time through the process. And we're not talking about an in-depth document here. So the investigation plan, is really an outline of the investigation. And within that document, there's just a few things that you want to cover. So the first is your parameters, or the mandate for the investigation. What is the thing that you are focused on? What is the question that you have to answer? And that's important for every investigation to have that clear in your mind at the outset, or at least clear for whomever is investigating the complaint. The other thing that you want to do is anticipate potential issues. And I'm working on an investigation right now where, for example, the complainant, they filed an anonymous complaint, and after reaching out to them, it's not clear whether or not they are going to connect with me for an in-person or a video conference interview. So all I might have to go on is the information that they've submitted via that written complaint through the employer's portal. If that's the case and I can't meet with them, now I have to game plan to look at, well, what information have they shared with me? What other witnesses are available, or can I identify who I might then need to meet with before I meet with the responding party, or at some point along the way, right? So spending some time to lay out the investigation and come up with a plan and have a plan A and a plan B that helps you to make better decisions and helps you to then create an accurate timeline of how long it might take to get certain things done, right? So as in this scenario I just pointed out, I might have one timeline for if I meet with a complainant, here's how the investigation might track. If I'm not able to meet with that person, then I've got an alternate timeline, because it then requires more interviews or me meeting with folks who may not be readily available, right? So whatever the case might be, again, it allows you to identify that as an issue and then make provisions for that delay. Scope. So we have already touched on this point, but it's worth mentioning again that scope is so important, right? It's the mandate. It basically gives you your directions in terms of where you're headed, and because you then know where you're headed, you can avoid going down various rabbit holes and chasing interesting things that may come up. So an example of that is an investigation that I just recently concluded. There was an individual who made a complaint of harassment, and one of the elements of the complaint was that one of her coworkers was stalking her and following her outside of work. And in the course of conducting that investigation, we met with the parties and reviewed their stories, and they both parties were consistent in terms of admitting that they ended up at a certain location on the same evening, and keep in mind that that this incident happened in a large metropolis, so it wasn't a small town where there's one main street and you can run into someone by happenstance. That these two individuals ended up in a random suburb where neither of them lived, and again, after putting the pieces together, we had reasons. There was more evidence than not, or we felt that the evidence was in favor that this individual had followed his coworker to that particular location. Now, another aspect of the complaint, or her version of events, was that he had likely followed her from her workplace. So, for the purposes of the investigation or determining harassment, in reviewing the evidence, I didn't necessarily need to go back to the beginning to figure out at what point he started following her and whether or not the origin of him following her was the workplace or the workplace parking lot. But if you maybe aren't experienced and you think it's important to tie his behavior back to the origin, you can go down that rabbit hole and then ask for all kinds of evidence in terms of reviewing his cell phone records for that evening, maybe reviewing other videotape evidence, maybe looking for the security footage from the employer's parking lot to see if the individual's car is identified in there, right? There's a host of evidence that you could then explore, which would take time and cause some delay in terms of your process. So again, just understanding what it is that you're there to look into, and then as a consequence of that, just knowing how much information and evidence you actually need to determine whether or not there is harassment, you can then decide, okay, well, I've got enough evidence now to make a conclusion on a balance of probabilities. I don't need to go that extra distance. I'm not here to prove this case beyond a reasonable doubt, and and the origin of this person, or their starting point for following their colleague, isn't relevant for a determination at the end of the day. So again, a little bit of planning and thinking through really helps you and saves you time when you're then in the moment and having to make decisions in the context of this investigation. Timing is another element that helps keep things on track, and we often think about timing as it relates to how things are unfolding once the investigation starts. But in my experience, keeping the investigation on track actually starts before that. It's how quickly, as an employer, are we acting to respond to the complaints that have come our way, right? So when there's a delay, and there are valid reasons for there to be a delay in the intake process and making a determination as to whether or not the incidents complained of trigger an investigation, and then find the resources to do that, whether that's in-house or externally. Certainly there's a delay and a nuance to these things. But when you have a material delay, and certainly a significant delay, now the investigator has to go back in time, and there's more of a backstory, right? So that's gonna take time. There is damage control that the investigator has to do. He or she has got to meet with these parties, and likely one, if not both of them, at this point are upset. So you've got to put the parties at ease, and then build a rapport to get meaningful information from them. So all of those things, the upset feelings and the having to go back several months, if not years, to get the backstory. All of that stems from the action that's taken, as this matter is unfolding. Maybe those are steps that are taken as the parties are being managed in the workplace, and then certainly the steps that are taken once a formal complaint has been filed. Another aspect is preparation, right? As you're doing that intake process, and you made a determination that an investigation is necessary, doing the preparation work to pull together relevant documents is another thing that helps save time for the investigator and to keep things on track. An example of that was a sexual harassment investigation that I conducted, where much of the evidence of the parties, or a significant aspect of the evidence of the parties, was alleged messages that were exchanged over the employer's chat application. And so there was these instant messages that were exchanged that contained problematic communications, and one party had deleted that chat history. So we worked with the employer's IT team to go back and retrieve that information as best we were able to. That's an example where on the front end, if that's something that you've identified in terms of documents or electronic communications, if those things are relevant to the investigation, then pulling that together for the investigator saves that individual time when it comes down to conducting the investigation. So you don't have a delay. Once the investigator comes on board, you don't have a delay then trying to retrieve the information. You got the ball rolling already, and that information is then prepackaged for the investigator, or is coming shortly thereafter. So that's another key step that can be taken during that intake or preparation stage. And we found, again, just going along with the taking action quickly, timely follow-up. Again, and there's many cases where part of what we're doing as investigators is putting the parties at ease, and that's because while the employer was doing all this work to review the complaint and do that intake process and find the right investigator, there hasn't been any communication with the complainant, and that person is sitting there thinking, well, these people just don't take my complaint seriously. There's nothing happening right now, and therefore I need to run off and get my union to file a grievance, or I need to run off and file a human rights complaint because, again, this complaint isn't being taken seriously. So to the extent then that you then have these parallel processes that are taking place, that could adds a layer of complication to the investigator, when that person's finally brought on board. So just having that that timely communication during the process is helpful. And then that gets us to just the importance of communications during the investigation. So early in my career, when I was doing this work, we would meet with the parties, and typically when it came to the parties or witnesses, you'd let them know that after you receive their evidence, look, I may need to meet with you for a follow-up interview, but and if that's the case, then I'll reach out to you. Otherwise, we're just going to continue on with our process, and then that person wouldn't hear from you likely until the end of the process. But I quickly realized that a lot of the delays in the files that we're working on were because we weren't getting cooperation from the parties that we needed. So we developed a system of regular check-ins with them. So when it came to the client, our client, the employer, we had a system of weekly check-ins, just so that the employer would know, hey, here's what's going on with the investigation. Here's where things stand. Here are the next steps, and that way they were always aware of what had happened and where we were headed, and then likely whether or not we're on schedule to conclude as on the timeline that we've indicated. When it came to the parties, we created a series of milestones where internally we knew that, look, after conducting an investigation, we want within 24 hours to have gone through that evidence and provided the complainant with a list of the particulars of their complaint. So here are the 10 things that you shared with me when we met. I just want to complain that these are in fact your allegations, and this is a thorough and an accurate and a complete list of the things that you're complaining of. And then we had another milestone where we wanted to make sure that we heard back from them after sending them this document, and we want to give them some time to digest that, to meet with their union representative or anyone that might be advising them, and then get back to us in a timely way. So what you don't want to do is to not have any milestones laid out. And again, this goes back to your investigation plan. When you don't have those milestones laid out, there's nothing that is sending you a signal to say, hey, look, here's what the next step is. Here's what you need to be doing, or that you need to be following up with this person. So then you might take a little bit of time to send them the particulars of complaint. You then expect that they're working on it, but then there's nothing really flagging for you. Oh, I need to follow up with this person. You look at your calendar, maybe it's been 4 days, and you're like, oh, I haven't heard from them. Let me follow up now. So you follow up, and the person might say, oh, I received it. Thank you. I'm just waiting for my union rep to get back to me. And then we'll circle back to you. Well, now you've lost, maybe a week, and now it's the weekend. So now this thing that that should have taken a couple days in the normal course now has taken a week. So you can see, right, now you're behind in terms of the anticipated timeline for completing the investigation. And that's typically how it happens, right? It's these little delays here and there that add up to weeks in the context of an entire investigation. So having these milestones and giving yourself then these red lights or these beacons that to look out for, and then you can say, okay, have I met that milestone or have I missed it? And what am I then doing to correct course? And you can then be more persistent with the complainant to confirm that the particulars are accurate, and then you can move on to the next step of sharing them with the responding party and engaging their availability for an interview. We talked about the importance of having the investigation plan, so having a mandate and setting goals or milestone events in the investigation. And the other thing that you want to do is identify pitfalls. So, you're going through the investigation and you're collecting this evidence, and there are a lot of cases where you've got several complainants. They're making a complaint against, there might be one responding party. And depending on the case, you may or may not, and let's just say the case hinges on credibility, right? And so you've got 5 complainants, you have one responding party, and this case comes down to a credibility assessment because you don't have a lot of witnesses. And maybe in terms of making that credibility assessment, you've got you have a witness who observed, say, for one of the complainants, right? So complainant 1 has a witness who observed a problematic interaction, and it's based on the evidence of this witness that you're able to say, you know what, I believe complainant 1's evidence over that of the responding party. So I didn't think the responding party was being truthful with me. I didn't find his or her evidence reliable in terms of their response to these allegations. So I'm going to make a credibility assessment in favor of the complainant. But maybe that evidence or that credibility assessment that you made for that complainant, it doesn't apply to the other 4 complainants. And how are you going to resolve that case? Because you're essentially, even though it's 5 complainants, 1 responding party, essentially you're dealing with 5 individual and separate complaints. You can't necessarily use the credibility assessment that you made in complainant 1's case and have that be used in to make a determination in the other cases to say that, okay, well, because the respondent wasn't reliable when it came to this case, he's also or she's also not reliable when it comes to these other 4 cases. How are you going to ground your credibility assessment then? So you can identify potential pitfalls there in terms of the evidence that you've collected and the additional work that you'll then have to do to establish credibility and make a determination in these other cases. So you can then say, okay, well, I'm going to have to dig a little deeper here. I have to meet with more witnesses. I have to find something on which to hang my hat to make this credibility assessment. So that's the importance of planning at the front end of the investigation. Also in the middle of the investigation, it's an opportunity to review the evidence and identify, see how things are falling and what direction the evidence is leaning in, and what additional work you have to do to bring things to make a determination and bring the process to a close. Another source of delay that we often don't think about is with the investigator themselves, right? You typically are choosing the investigator because of their background. They have expertise in the particular area that you're looking to have them investigate. They have a good track record, and so you bring them on board. But maybe you haven't asked the question about how many other investigations do they have on the go at any given time. I've heard from employers where they've brought in an investigator. They thought they would have one person doing the work, and then they end up with that work being shared between a handful of different people because the lead investigator is busy with other cases, and so they bring in somebody else. So the lead investigator might meet with a complainant, but then you've got somebody else who's meeting with a witness, and you might have yet another person who is meeting with the responding party, and then who knows how they're pulling together all of that evidence at the end of the day to make a determination. That might not be the quality that you want. You might want the consistency there of having one person who is handling your case and being able to see it through to completion. So that's something to be mindful of is, how many cases are they juggling at a given time, and can they dedicate the time necessary to give your investigation the priority that it deserves. Another question that you would want to ask of the investigator is, what's their contingency or backup plan if there's an illness or a family emergency, right? We do this work, and the work is dynamic, but we know that life is dynamic as well. And there could be an illness in the family, or someone could pass away. And now that person, that investigator, has to attend to that personal issue. Is there someone else on the team that can step in and assist? So you want to ask about any contingency plans that might exist to the extent that the unforeseen occurs. And again, it's understanding that this, when it comes to conducting investigations, that there are a lot of twists and turns, and we can only do so much to make the process and the timelines predictable. But it's important to assert your control over the things that you can control, and doing some planning on the front end of the investigation, identifying these key issues that we've reviewed with you, and then coming up with a game plan to respond to that. That's going to help you to put in place a process that will stand up to scrutiny, and a process that will ultimately give you predictability with respect to your investigations. So I trust that information and those strategies are helpful to you. And we'd like to open up the floor now for any questions that you might have.
Hi, Dorian. Hi, everyone. This is Neha. We've got one question from a participant. What volume of caseload would be reasonable, and how many investigations are reasonable to take on?
That's a great question. I can't really. I can only speak to our own internal metrics, but I would say because it all depends on the type of cases as well, right? Like we all know that there's you could have one investigation, but that one investigation is is a high profile one, or a significant one with multiple parties, in which case that's going to take most, if not all, of your time. You might have a few routine investigations on the go, but I would say generally speaking, if you have more than 4 at any given time, that's a lot. I would say that's a full plate. So I would if I was interviewing an investigator and they had more than that, that would give me a reason to ask them, can they reasonably take this on, and what allowances do they have, like in their schedule, to do the work that's required on the investigation that I'm discussing with them. So I would say if we had to bring it down to a number, 4 would be a reasonable number. But again, keeping in mind that investigations come in varying levels of complexity. So you got to look at the context of that in order to make a conclusion at the end of the day.
Thank you. I don't believe we have any more questions. We've got one question come in.
Yeah.
How much flexibility do respondents have in determining when they meet with the investigator? That is, can they delay to a certain point?
That's a good question. So investigations are fluid in the sense that there are no independent set of rules like you have in the civil litigation process that indicates things have to happen on a certain timeline, right? Or by a certain date. When it comes to investigations, it's really the internal process and policies of the employer and the investigator. So, but certainly the parties want to figure out what happened and bring things to a conclusion as quickly as possible. My general rule is that the responding party should have adequate time to review the allegations and prepare for their interview with me. So, you look at the beginning of the process, you want to collect the allegations and give the responding party enough detail about what the allegations are, so that that individual can understand what the case is against them. They can go through their documents and their emails and come prepared to a meeting to provide a fulsome response to those allegations. So you're looking at what's reasonable in the circumstances, and in most cases, it doesn't take someone more than a week to prepare for an investigation interview. Again, it depends on the volume of allegations, right? I had one case where it involved a professor, and there were 10 complainants that came forward, and as you can imagine, there's each person has a handful of complaints, so it's going to take the responding party some time to meet with their faculty association rep and to prepare for that interview. And then even the interview itself, you've got to allow for a couple days to get through these 20 to 30 allegations. So each case is unique, but I would say, again, generally speaking, for the average case, it usually doesn't take someone more than a week to be able to understand the allegations and then participate in an interview.
Thank you. We've got another question. At what milestones would you typically provide an update?
That's a great question. So with respect to the employers, we provide an update weekly, right? We want them to know every week, here's where things stand. Here's what we anticipate the next step to be. Here's why that did or didn't happen. And so they're always aware in terms of what's happening with the investigation. When it comes to the parties, you want to keep them, the check-in is not a weekly check-in, but it's more, after meeting with the complainant, letting them know, okay, I'm going to, review these allegations, and the next step would be, to meet with any relevant witnesses and then or meet with the responding party. So they're just aware, here's what's happening next. Maybe within a couple of weeks' time, you might say, look, we're still at the interview stage of the investigation. We anticipate concluding that, within a couple of weeks' time, and we're looking at rendering a report, by the end of the month or whatever the case might be. So it's more just letting them know the rough timelines. I would say more here's when we've concluded here's when we've concluded or we anticipate concluding the interview stage. We're now working on the investigation report. Here's when we anticipate submitting a report to the employer, and then after that, the employer is going to review our findings and they'll be in touch with you with respect to the conclusions. So it's I would say that's like the rough thing. You're probably beginning, middle, and towards the end, you're letting them know where things stand.
We've got a good question come in. In terms of best practices, where the collective agreement is silent, should the union be present when interviewing witnesses, or only those who may be disciplined as a result of the process?
That's a great question. So generally speaking, when it comes to collective agreements, the union has the individual has a right to union representation at the point of discipline. When it comes to the investigation process, then where it's just the employer collecting information, that right wouldn't, on its face, be engaged, and it's important to note that the right belongs to the employee, right? So it's just because the employee has the right to have union representation there. We've certainly had cases where the individual did not want to have their union rep present for whatever reason, right? They just wanted to attend on their own. So I would say when it comes to the responding party, right? You've got these allegations made. You've got a responding party. Clearly, based on the outcome of the investigation, there could very likely be grounds for discipline, up to and including termination. I think that's a clear case where you want to let the person know of their right to union representation. In terms of other witnesses you meet with along the way, you would let them know that they have a right to representation as well, but they aren't being make it clear that, for example, especially for a witness, that you're being called into this investigation because your name has been mentioned as someone who may have helpful information to share, and you're not accused of any wrongdoing, and therefore there is no reasonable prospect of discipline for your participating in the investigation interview. And in that case, it's it's their choice if they want to have someone there, but it isn't necessary. And then you leave it up to the up to the individual in terms of what they like to do. I mean, part of the exercise here is obviously respecting the collective agreement. Where in the case of the responding party, you clearly have to do that. With the other individuals, it's more a matter of maintaining that labor relation, that balance, right, between maintaining labor relations harmony and conducting an efficient investigation. We've seen cases where there are some unions or certainly some individuals within certain bargaining units that their goal might be to disrupt the investigation or disrupt the way that investigation interview is conducted. So their presence isn't really helpful to the investigator or to the witness, and I know those are difficult situations for the investigator to manage. But in terms of just trying to figure out should we allow this person to have representation or not, I would generally err on the side of allowing that in a unionized environment, allowing the representative to be there, and then letting the investigator or that investigator should know that they can assert themselves with the representative to let them know that, look, here are the expectations in terms of how you are going to conduct yourself at this meeting, right? That you need to get as the investigator. I'm entitled to get this information from the witness directly, that you're here as a support person, that you're not here to interfere or to interrupt or to in any way obstruct the information that I'm getting or the answers that I'm getting from the witness. So, a lot of, if you're dealing with a contentious union, it makes it that much more important to work with an investigator who has that experience and who can manage the process. Because, like I said, I've seen a lot of cases where, depending on who the union reps are, they can completely derail a workplace investigation. So, there's a lot of judgment calls and very few bright line rules there. But I hope I provided some general guidance, and I'm happy to have a one-on-one chat with the individual who posed the question, and we can unpack that a little bit more.
Thank you. I believe that's it for questions.
Yeah, nothing else coming through. Okay. Well, I want to thank everyone for your participation. As always, thank you for the great questions, and we look forward to putting these events together for you, and we trust that you take helpful strategies away to use in your own practice. We are always open to receiving feedback, and so if you have any questions or comments about this presentation, please let us know. And if you have suggestions in terms of future events that future topics, that you would like us to cover, please do let us know that as well. And as we plan our next series of webinars, we'll certainly take those suggestions into consideration. Thank you very much for your time, and we look forward to seeing you again soon. Bye, everyone.